Well, hello, everybody. Long time no talk. We are back. My name is John Humphrey, the chairman of the TCC. I'm joined by Doug Kennedy and our councils, Jim Stang and John Lucas. And it's been a very busy day full of negotiations. But the late breaking news is that the BSA has filed and we have signed to a restructuring support agreement, and also known as an RSA. So we're going to try to outline that tonight. We're going to go through an agenda of the insurance, non-insurance, the BSA and the locals. We'll talk about chartered organization and insurance companies, what an RSA is and a term sheet, what the timeline might be forthcoming, what a trust distribution procedure is. Doug's going to cover some of the non-monetary demands that we were able to get secured, and then we'll tell you what the next steps are. We have opened up the Q&A, and John Lucas will be fielding those questions. If you enter your name in the question and we respond to it online, people will see your name. If you would rather put an anonymous question, just put it forward as anonymous. So thanks for coming. We know we're on the heel or the eve of a 4th of July weekend, and I, for one, am grateful for all the hard work that's been done. You know, in a mediation, I guess I've heard that if it's successful, everybody's a little bit unhappy with the outcome. So there's going to be some really great things about this process, and there's going to be some things that people aren't particularly happy with, but our desire was to get the most we could get for you guys and do it in a time frame that was more expeditious. So with that, I'm going to turn it over to Jim Stang and let him outline what is part of this agreement.
Thank you, John. For those of you that attended last night, I hope that John Lucas and I are looking a little fresher. It was a very long 2 days. I think in terms of actually sitting in active mediation, it was over 24 hours between the 2 days. And I can only handle so much coffee. But we've had a bit of a day of quote unquote relaxation. So hopefully, some people said yesterday that I looked discouraged or tired. I was tired. I was not discouraged. So let's talk about what's happened in the last few minutes. Literally the last few minutes. The Boy Scouts have filed, as John reported, a restructuring support agreement. And for those of you that were on yesterday, I'll try not to be too repetitive, but there are more people on tonight than there were yesterday. So I want to give some of this terminology and explanation. The restructuring support agreement that was signed was between the Boy Scouts of America, an unofficial committee of local councils, the Tort Claimants Committee, that's us, the Coalition, which is an unofficial committee of people and lawyers who collectively represent 60,000 people. So a lot of accountability with survivors for this agreement. I mean, the committee is a fiduciary to all of you, but a group of lawyers representing 60,000 of you have signed this term sheet. And then you've got someone called the Future Claims Representative, who represents people who, as of the bankruptcy date, were minors or had repressed memory, which is a psychological state that basically you didn't remember what happened to you. So we court appointed someone who's kind of like a guardian to represent those folks. So those are the parties to the restructuring support agreement. And what the restructuring support agreement says is that we who signed it support the plan that is outlined in the attached. And the attached is called the plan term sheet. And it goes through in some detail, certainly not as much detail as the plan itself will, and outlines the major subjects that will be treated in the plan of reorganization. A critical part of the term sheet is what we call the trust distribution procedures. And while it is part of the term sheet in terms of the subject matter covered, it is a separate document. So, and it is attached to the restructuring support agreement filing that we'll talk about exactly where you can find it over the course of this presentation. So you've got the restructuring support agreement, RSA, plan term sheet, the TDP, the trust distribution procedures, and as part of the TDPs, there's also an analysis of statutes of limitation. And I don't want to unduly focus on that at the moment, but I know a lot of you have questions about what is the effect of my state statute. A lot of people on this call were terribly injured decades ago. And while that's often used by people to kind of minimize your claim, it does have a legal importance, and we'll talk about that. And then there is going to be some additional documentation filed. Tomorrow, the Boy Scouts will file the actual plan of reorganization. It will be the 4th amended one, and a disclosure statement that explains how the plan works and is meant to give you enough information so you can decide in consultation with your attorney, if you have one, or if you get one, the important information so you can make a decision to vote for the plan, to vote against the plan, or to object to it, or to support it. We who have signed the restructuring support agreement are going to advocate that you accept the plan. There's a lot of detail, the expression much between the lip and the cup. There's a lot of detail to work out, but the broad parameters have been agreed upon and are set forth in the RSA, the restructuring support agreement. So, and from time to time, John's going to interrupt me, and John Lucas is going to say, no one wants to hear what you're talking about, Jim. This is what they want to know. So he will interrupt me with questions, and we might change subject, if not mid-sentence, at least mid-thought. So let's go down and talk about what this RSA says. What does the term sheet say? The first thing is, how much are the Boy Scouts putting in? Now, I'm not talking about their insurance companies. We'll get to that in a few minutes. But how much are the Boy Scouts putting in? And Boy Scouts means Boy Scouts of America, not the local councils. We'll talk about that after we talk about BSA. BSA is putting in a package of property and cash totaling $250 million. This is about twice as much as it originally offered. It will consist of cash. It will consist of real estate, specifically Scout University, which is in escrow, by the way. So either we'll get the property or we'll get the sales proceeds. The distribution warehouse, subject to a lease, because the Boy Scouts will continue to use it, but we could sell the property subject to the lease. It's a lease back to the Boy Scouts so that they have continued use of it. It's art collection, a group of oil and gas royalties, and based on appraisals, the estimated value of those assets is $250 million. We have been asked, what if the building doesn't sell for the appraised amount? Well, if it sells for more, we get to keep the upside. If it sells for less, we suffer the downside. There is no backstop to the 250, but the folks who will be in charge of the disposition of those assets will work as hard as they can to get more than the 250, but there is no guarantee to that number. When BSA transfers that money, and again, we'll talk about the insurance in a minute, but when it transfers that money, property, and its insurance rights, it is done. It has made its contribution to compensation of survivors. And for those of you who, well, I'll leave it at that. What are the local councils putting in? So the local councils have participated in the bankruptcy case through something that we call the ad hoc, ADHOC, local council committee. It's not an official committee appointed by the court. but the people who have volunteered to be on that committee and their counsel have been interacting since the beginning of the case with all of the local councils, which number about 250. We have talked a lot on these town halls about the local council assets. And the local councils are going to put up collectively approximately $600 million. The disclosure statement will include information about how much each local council has been asked to put up. And when I say asked, the ad hoc committee has been in negotiation with the individual councils and has, in a sense, sent a bill to each of them. Now, it's not a bill they must pay, but it is a bill that the local council committee thinks is their fair contribution to the total of $600 million.
Hey, Jim, I might interrupt you for a moment. You
Sure.
might just cover briefly the legal structure difference between BSA National and each one of the local councils, and the
Sure.
fact locals are not in bankruptcy.
Okay, let me just finish the thought about the property and then I'll circle back to it. So what are the local councils putting up? What does that $600 million consist of? It will consist of $300 million in cash, $200 million of real estate, and a $100 million promissory note. The $300 million in cash, really can't speak to that, it's cash. On the real estate, it is going to be at least worth $200 million based on appraisals that this committee has undertaken, that the debtors have undertaken, and we will figure out which properties are actually going to be contributed, but it's going to be based on appraised values. We don't anticipate that the local councils will immediately transfer the properties to the people in charge of running the compensation program, because the last thing we want to do is be the largest operator of camps in the United States. Not set up to be a real estate management company, but there will be commitments that will be enforceable to ensure that those properties are being marketed, and when sold, that the sales proceeds will come for the benefit of survivors. And then finally, there's a promissory note. It is geared off of monies that will be excess for the local councils. There are a lot of protections being built into the term sheet that make sure that there's no funny games going on about whether the cash will be available to pay that note. The BSA is a corporation created by the federal government, chartered by the federal government, and it is the entity that's in bankruptcy. It has agreements with these things called local councils that in effect allow the councils to go out and create troops. The local councils are corporations in the state where they exist. So the LA Boy Scout local council is a California corporation. It has obviously very extensive relationships with the Boy Scouts of America, but those local councils are not in bankruptcy. So part of the dynamic we have is how to get the local councils to put up money and property and give them relief from the abuse claims that are being brought against them. It has been a very complex part of the job, which is multiplied by the fact that there are 250 of them. And while this ad hoc committee has tried hard to manage the process, they all have their own boards and have similar but also different interests. So that's BSA contribution, that's local council contribution. In addition to the cash and the property that I've mentioned, the BSA and the local councils are also assigning to a settlement trust, which is the vehicle for handling the cash and handling the real estate and the paintings and the royalties. They are assigning their insurance rights to a trustee who has been selected by joint agreement of the coalition and the people it represents, the Tort Claimants Committee, and other parties in the case. That person will not be appointed until the plan is approved, or not, he's not been appointed yet. But the insurance rights are assigned because at the present time, and I'll talk about Hartford Insurance in a moment, but except for the Hartford Insurance Company, there are no settlements with any insurance companies. All of the property coming into the trust is coming from cash, property that is being put in by Boy Scouts and the local councils. There are also no settlements with any chartered organization. Those are the entities that sponsor the troops. So there is not a single settlement with the Church of Latter-day Saints, who, while not currently a chartered organization, is not a chartered organization, was at one time. There's no settlements with a Kiwanis Club, with the local fire department, with a Catholic diocese, with a Jewish synagogue. No chartered organization has made a settlement with any of the parties in the case. There have been discussions with some, but no agreements. So this trust will have an assignment of the insurance rights, and people will have their rights still against chartered organizations. And we'll talk in a few minutes about how one enforces those rights. So John, Lucas, I'm going to take a pause for a moment. Tell me if there's anything that's coming up that you'd like me to address before we go into a discussion of the trust distribution procedures. John, you're on mute. If you want me to answer any questions.
Thank you, Jim. A number of the people, and hello and good evening, everybody. And one thing I'd like to say is that many of you are thanking John and Doug and the firm for the work that we've done. And so we appreciate your comments. And so if I don't respond to a thank you, that doesn't mean I'm ignoring it. I'm just sort of saying out here, thank you very much. It's much appreciated. And we're grateful that you're finding us valuable. So thank you for your nice comments. Jim, a lot of people are asking about the insurers. And what they're asking about is, well, why aren't they part of this? And why are the insurers filing an objection and saying, hey, they weren't part of the negotiations? And so does that mean that if the insurance isn't part of this plan, that the survivor's attorney has to sue an insurer? Like, what happens to the insurance?
Okay, so let's talk about Hartford for a moment. Because I said there are no settlements with any carriers, and then I kind of carved out Hartford. Hartford Insurance Company is one of the major insurers of the Boy Scouts. And generally, when we say Boy Scouts, we mean also the local councils. And depending on the years, the chartered organizations. Because when you look at the insurance policies, they have a list of people who are covered by the entities that are covered by the insurance. So BSA is at the top of the list, but not in any priority, but just at the top of the list. And then you've got local councils, and then you have chartered organizations. The debtor reached an agreement with the Hartford Insurance Company to pay $650 million for settlement of approximately 24,000 claims. The Tort Claimants Committee, the coalition, and the future claims representative vigorously, is an understatement, objected to that settlement. We thought it was inadequate. It didn't cover enough dollars, and it had an impact on discussions with other insurance carriers. So we said in court and in pleadings, and we have said before this group, that we would not support of any plan that includes the Hartford Insurance Company settlement. And the pleading that was filed today by the Boy Scouts says, and while I personally haven't read it, talked about it to the point of being nauseated, what they're saying is, Judge, tell us if we have to include the Hartford Insurance Company settlement in our plan, because we can go forward with the plaintiffs groups in a cooperative spirit that we're talking about tonight if the Hartford insurance policy settlement is off the table. But if you tell us, because we inked a deal with them, that was subject to your approval, Judge, that we have to include it in our plan. The parties to the restructured settlement agreement can bail on it, and we can go our own path. So one of the things Judge Silverstein will be deciding on July 20th and 21st is whether the Hartford deal has to be in the settlement. I don't know what Hartford's going to say. I suspect it's going to say that it must be, but we'll see. So the Boy Scouts basically have said, we have a path forward with the plaintiffs groups if the Hartford insurance settlement is off the table. But the question went to the bigger question of where are the insurers? You know what? That's our question. Where are the insurers? There's a lot of back and forth about have they been included in the negotiations or not. And I'm not going to get into the details of that because A, it's supposed to be confidential, and B, it doesn't matter. We don't have any settlements with any of them. So the carriers are filing all sorts of objections that the process has been unfair, that they have been excluded from the process, and that everything needs to slow down because their rights under the insurance policies are being impacted. Now, the main right we're focused on is their right to pay, their obligation to pay. But there are rights that they have regarding how claims are reviewed and the duty of the people who are covered by the insurance to cooperate with the insurance companies. And that's a tension that exists between what has been proposed and what the insurance companies expect, because the insurance companies are not happy with the processes that we'll talk about in a few minutes as to how claims are going to be valued. So we would like to reach global agreements with all of the carriers. That is the most expeditious way of getting all of you compensation in a timely way, but it has to be the right amount. Hartford was not the right amount. It has to be timely, and we're just not there yet. So there's an old expression, and I suspect there are insurance people on this call, so I'm going to be careful about it, which is insurance companies like collecting your premiums and they hate paying out. I'm not going to say the insurance companies are operating in bad faith. It's not my place to say that, but we would like to enable the Boy Scouts and the local councils to realize something from the payment of decades and decades of premiums. We're just not there yet. But I will tell you that we will be in cooperation with the coalition, with the future claims rep, and so long as those policies are still with the Boy Scouts, they will be assigned when the plan is approved, that we hope to work together to get reasonable settlements from the insurance companies. So anything else, John, before I move on to the TDPs?
No, I think that the TDP is a good place. Let me just sort of give you a little bit of a sort of comments coming in, is that there are a lot of people that are wondering, people have specific questions about, well, what about my claim? This happened, or what about my claim? That happened. But I think what people really sort of want to understand is, what is the TDP? How's my claim going to get valued? And then really the $64,000 question is, when am I going to get paid? What's the timeline really look like?
Okay, well, I hope it's more than $64,000. I got it. I understand. So the purpose of the trust distribution procedures is to set out how the claim will be valued. And once the claim is valued, how it will get paid. So I want to make sure everyone understands there's a real distinction here. What is the value of your claim and how much you will be paid on account of that value? It would be our hope that you'll get paid every cent of the value of that claim. But that will depend a lot upon the outcome of the negotiations or litigation with the insurance companies and with the chartered organizations. I know that we spent time in arguing against the previous plans that when you divide the dollars by 84,000, you get single-digit thousands. And anyone who's gotten their calculator out and took 850 million with some question marks around that, because as I said, there's no guarantee on certain values, and divided it by 84,000, You did not get an overwhelming number per person. I get it. The purpose now, if this plan were confirmed tomorrow, the purpose of the plan is to finalize payments from the insurance companies and the chartered organizations. And so we did the best we could with the legal issues surrounding BSA's assets and the local council assets in the context of moving this case forward. Is it every dime that they have? No, it is not. But it is the best that we could do in cooperation with the coalition, who speaks for a vast majority of the survivors in this case, to get what we got. So let's focus on the TDPs. Again, purpose is valuation of your claim. And I'm going to use a reference to the word trustee, because the trustee is going to run this process with lots of staff and lots of helpers, but we'll just refer to the trustee. So we got your proofs of claim, and you're going to be asked to fill out another form that gives us more information about your claim. But you're going to have a couple of options along the way as your claim is valued. The first option is going to be you've signed your proof of claim, not your lawyer, but you, and you have completed it. No blanks, right? Substantially completed. And you submitted it on time. Although if you had your lawyer sign it, it's okay if you signed it now. But in terms of getting the claim form in initially, it hadn't been on time. You will be offered an opportunity, just based on the fact that you swore under penalty of perjury, that the facts in the statement are true, and that the statement is complete, and that it was filed on time, to get an expedited payment. I'm sure the next question is going to be, how much is that expedited payment? So it's $3,500. And some of you may say, oh my God, I would never accept $3,500. And some of you might say, you know what, to be done with this, I'll take it. You're not required to take the $3,500, but the plan contemplates that it will be available. Now, if everybody wanted $3,500, there's not enough money to pay that, but we're not expecting everyone will take $3,500. So there is what we call the expedited payment. Okay, everybody else, what are your choices? There is a process for valuing your claim. It is spelled out in detail in the TDPs. And without getting too much into the details, the abuse is broken into tiers, ranging from penetration to non-touching. And there are what we call base amounts for each one. So just as an example, the base amount for a penetration claim is $600,000. Now, again, folks, keep in mind, this is the value of your claim, not how much you would necessarily get. Now, there are factors that will increase that value, and they are spelled out in detail in the TDPs. Those factors could include that you were abused several times as opposed to one occasion. I don't have all of we call these scaling factors, SCALING. There are scaling factors that will increase the amount of your claim, and there are scaling factors that will decrease the amount of your claim. And I don't intend to go into detail as to each one and how much does it increase it by 20% or 40%. You're welcome to go through the TDPs, and maybe we'll have a separate session specifically on the TDPs and these factors. But I do want to address the statute of limitations. After some very, very difficult negotiations, we, the Tort Claimants Committee and the coalition, reached an agreement on how the statute of limitations will affect the value of your claim. Everybody walked out of that room bloodied, folks. Just want you to know it was really, really tough, because it would be our goal that statute of limitations would not apply. If we could live in that world, we would. But the people who are getting sued, be it BSA or the local councils, but let's not forget our friends, the insurance companies, look at this and go, if we were in court, what would happen? Now, that was part of the negotiations because no one knows with absolute certainty what would happen in court. But a lot of people had very, very strong ideas about what would happen. So anyway, I think I've made my point that this was not an easy part of the deal. But there's a chart attached to the TDPs that groups the states into, I think, was it John, 5 tiers?
Yes.
Yeah. And it ranges from states that have no statute of limitations, such as New York, California, New Jersey, and some others, Guam. And the bottom is states where it is extremely difficult. And I'm saying this based on the collective experience of trial lawyers who literally have hundreds of years, collectively, hundreds of years of experience litigating sexual abuse claims. And those states in that category get highly, highly discounted. And then there's the in-between. And the chart is what the chart is. I want to make clear, the chart has the support of the plaintiffs groups. I won't say it has the support of every plaintiff's lawyer because that would be untrue, but that is where we came out collectively. And you should find that page in the TDPs, look at your state, and you can see what's proposed. And I just want to reiterate, we support the plan, but the plan has not yet been approved by the Bankruptcy Court. So if you've got problems with any aspect of what I'm talking about tonight, and what John and I and Doug and John are talking about, you got to talk to your lawyer. But we do support the plan.
Hey, Jim, just one thing though about, as you were going through the TDPs and you were talking about the statutes, there have been some questions about, about the windows that have been created. Can you maybe just sort of describe what a window is? Talk about maybe Louisiana, Arkansas,
Sure.
Colorado, so on and so forth, and even New
Sure.
Jersey and stuff too, because people are even asked about New Jersey, and that's not new. But
Right. Well, John mentioned Louisiana, Arkansas, and he could have mentioned Maine because in the last 90 days, those states created these things called windows. So let's assume that your state statute said that for child sexual abuse, you had to sue by age 23. And you're 45 years old. You can bring the lawsuit, but you're going to have it dismissed. I mean, this is a hypothetical, right, folks? So there's always exceptions to the rule, but your case is going to get dismissed. You're not 22 years old. So this is a state by state issue. There is no federal law on this. So New York, a couple of years ago, said, you know what? We're not going to tolerate that situation. And for a 2-year period, what has now become a 2-year period, no matter how old you are, 45, 80, 63, you can file a lawsuit for the child sexual abuse you suffered, and it will not be dismissed because you're too old. That period of time is called a window. Now, some places like Guam eliminated the statute of limitations entirely. And so while we do refer to, sometimes people refer to Guam as a window, it's a window that's never going to close. In New York, that window closes on August 13th. Some people say it's the 14th. Be safe, it's the 13th. So the window opens, which means that you can sue no matter how old you are. And for most places, the window will close by a date certain. So Louisiana, it's a 3-year window. Now, we have, Louisiana opened its window 2 weeks ago, long after the Boy Scouts filed their bankruptcy. But the TDPs reflect that Louisiana creditors are not discounted for their claims on the basis of the statute, even though on the day they filed the proof of claim, probably a lot of them were subject to a statute defense. So what happens? Someone might say, well, okay, Christ, I unfortunately live in Utah. Sorry, but for statute of limitations periods, it's unfortunate. It's near the bottom of the barrel. What happens if Utah tomorrow, or not tomorrow, but a year from now, opens its statute of limitations. Am I stuck with the old law? And the answer is that will be taken into consideration in the process of evaluating your claim, because this process, you folks, you're not getting your money in the first 3 months after the plan's approved. It's going to take a period of time. And over the course of that time, I think we've given it, what, 12 months, John? If during 12 months after the plan's been approved, your state changes its statute, that change will be reflected in the valuation of your claim. Was I right about the 12 months, John?
Jim, I'm not positive about it on the top of my head. So
Yeah, but there is a time period.
I don't want to
So-
confirm that to everybody.
So there's a time period. So that's what a window is. So the TDP says to creditors, you want to take the $3,500 expedited payment. If you filled out the claim forms properly, you'll get that. Then you are in this process that's run by the trustee to value your claim. Now, some people might say, you know what? I want to sue. Nice meeting the trustee. Love your TDP, but I'd much rather be in court. And the answer to that is it's up to the trustee to decide. Because these lawsuits will have an important impact on how people are negotiating with the insurance companies. And it's important to have control over what that litigation looks like from the perspective of the trust, which is trying to maximize the insurance coverage. So if you want to proceed with your lawsuit, the trustee will sit down with a identified group of plaintiffs' lawyers. They'll vet your claim and they'll decide whether or not you get to bring your lawsuit. We call that the litigation out. Now, some of you may have been involved in class actions and you've heard, well, you get that postcard, right? And it says, if you would like to be not within the class, just check the box and mail it back. It's not the way this is working. It's not the way, in the sense of what's been proposed. You can only continue your litigation. And this is a general rule. There are some exceptions, but for the most part, you can only continue your litigation if the trustee says, okay, as in terms of getting out early to have your claim valued in the court system. There are exceptions. Frankly, the exceptions are fairly complex. I don't think it would serve our interest tonight to get into all the exceptions.
So Jim, maybe we
okay.
we got about 20 minutes left. So maybe we should talk a little bit about like the non-monetary stuff. Maybe Doug could cover that, and then we could talk about a timetable.
Sure. Let me just finish with this thought, John.
Okay.
It is the goal of the trust to get settlements done with the insurance companies. There may be litigation before we get to those settlements, but the goal would be to get fair settlements from the insurance companies, fair settlements from the chartered organizations, to bring those monies into the trust and use either the trust distribution procedures valuation of your claim. The machine will produce a dollar amount for each of you. Or if you were allowed to go into the court system, if you got a judgment, to use, again, generalization, to use that value and get distributions. That's the goal. That's what this is about. So one of the things that we have worked very hard to do has nothing to do with money. And that's why we call them the non-monetary commitments. And Doug has been working very hard to get this done. And I just want to add this, and I'll turn it over to Doug. He has repeatedly in these meetings reminded you that bankruptcy is a business. The bankruptcy court has some ability to compel the Boy Scouts to do certain things for the protection of children going forward. Now, Doug will talk about what that process has been like and what we've come up with to date. But there is a tension between the business side of this, how much money you're going to get and when, and affecting the future operations of the Boy Scouts as to how it will be required to protect children above and beyond what its current program is. So Doug, with that, please go ahead.
Thanks, Jim. And of course, as I'm about to speak, we have a storm coming in, so I'm going to probably have to tee this over to John Humphrey if I lock up here at some point. Jim, I appreciate that. And I've been reading the comments here furiously, and thanks to everyone who's thanked us for our hard work. If this is the first time you're seeing us, John Humphrey and I we are victims of child sexual abuse when we were in the Boy Scouts, and we've been part of a 9-person committee, survivors, and we have been working diligently. We've been trying our best to do everything we can to get the most amount of money possible. And I know that on everybody's mind is, how much am I going to get and when is that going to be? And right now, the one piece of advice, it's kind of like drinking water from a fire hose right now. There's so much getting thrown at you. This is going to take a while, and the documents are going to be uploaded to the TCC BSA website so that you can review them. We're going to have other town halls to be explaining the process. But I also want to mention too that a number of the questions are very, very individual, related to your specific case. And that's the reason why the TCC has recommended that people seriously consider having an attorney, because our professionals can't address individual cases because in some case they rely upon state law. So there's also a statement on the tccbsa.com website that talks a little bit about why you should think about having an attorney. Now, having said all that, Jim did mention that there are some non-monetary issues that we also bargained in this agreement, and I think they're important. If you are a victim of sexual abuse, these should be very important to you because you don't want to see this continue. So the Boy Scouts have agreed to allow for the formation of a committee that will do a few different things. So this committee will be made up of members of the Boy Scouts, also local councils, and most importantly, will be made up of people that were also victims of abuse. And this committee is going to look at the Boy Scouts Youth Protection Program. It's also going to have a hand in hiring an outside entity that has expertise in crafting youth protection protocols and training programs and rules. And that committee is going to be looking firsthand at those recommendations and be engaged in a discussion with the Boy Scouts about what those are going to be. Most importantly, that work is going to be transparent. The results of that work are going to be posted, are going to be communicated. So what we're really trying to do is make sure that all of this is transparent and everybody has an idea of what's happening going forward. Also, part of this committee's responsibility will be to address what are called the ineligible volunteer files. For many years, the Boy Scouts held files of volunteers that had been accused of misdeeds, including sexual abuse. Those files need to see the light of day, but it needs to be done in a robust manner that is appropriate. So this committee was going to be looking at this list and figuring out how to release the most appropriate names on there. When it can't come to an agreement, the Boy Scouts have agreed to allow a neutral third party to review the files to determine which ones are going to be released and to make sure that no one who is falsely accused, their name is attached to it as well. And part of these processes will be ongoing reporting so that we'll have an idea in years to come whether or not the youth protection program is working, what changes are being made, and what the impacts of those changes are. So we know that for everyone, the money is a critically important part of this. We want what happened to us to stop, and we think that the formation of this committee, as well as a committee of survivors that are going to be part of the trust operation as well to advise it, we think that these committees are critically important to set things on a much better path in the future. So
yeah, thanks, Doug. You know, the institutions in this country that are supposed to protect children are failing at scale, whether it's the Boy Scouts or the Archdiocese or USA Gymnastics or the various universities. And when Doug and I realized that since youth protection went into practice at the BSA, 11,000 of our 84,000 claims are in that window. And we just felt like it was very important. I read an article today that said every 68 seconds in America, an American is being sexually abused. And we just think it's time to step up, to make things transparent and help change what's happening in American culture today. So we felt very strongly about that. Jim?
Thank you, guys.
Yeah.
John, go ahead.
Can you, you did talk about the statutes. Can you maybe just sort of talk maybe a few more words about the TDP? Because I realize they aren't a simple thing to sort of break down and explain how it's going to work out. But there are a lot of questions. I mean, just because you're in one state versus another state, that isn't the be all end all of what's going to determine the amount of your claim. There are a lot of factors. And so
Right.
the questions that I'm seeing a lot is, well, hey, where am I in my state? What percentage is it, or what range is it and stuff?
Okay,
Just one factor.
sure. So we're going to work off penetration claims because that's the number I can remember, which has a base amount of $600,000. And folks, you need to go look at the TDPs because I'm just doing this as examples. I just don't have the exact numbers in my head. So please do not lock in on the math I'm about to do. So you have a base amount, this I do know, you have a base amount of $600,000. And you write up in your submission to the trust, I was abused 5 times a year for 3 years. The trust has the ability to evaluate that and say, you know what, I'm going to increase your claim by 10%. So instead of it being worth $600,000, because of your repeated instances of abuse, it's now $660. Or something in between 0 to 10% increase. And you have suffered severe mental distress. All of you have suffered mental distress, but yours has been particularly severe, and you have been hospitalized for suicidal, I forget the word they use, attempts of suicide. And so we're going to increase your claim by 20%. And so now, instead of being at 660, we added another 120,000. So, do the math. 600 times 1.2 times 1.3. And as John has put up as a screen share, you can see this concept of, for those who were abused more than once, how your claim increases one time. In addition to the one instance is 1.25. If you were, I'm sorry, this is, I'm looking at someone who, your abuser abused more than one kid. And so, someone might say, well, why is that important? It goes to, if you're in state court and your abuser abused multiple kids, it helps with the quote credibility of your claim. So you can see under this paragraph that says abuser profile that there are multipliers that would go to your claim. And there are limits. It doesn't go on forever. Then there's the impact of the abuse. It can go up, it can increase your claim by as much as 50%. And you'll see the mental health issues. Now, these are all what we call including, meaning they're examples. So self-destructive behavior, that's the suicide I was talking about. You just read them: physical health issues, interpersonal relationships, vocational capacity, academic capacity. Did you fail in school because of the issues you were suffering from abuse? So that's what gets you up. And then we have the stuff that reduces. And those are called mitigating scaling factors. And so we've identified through close consultation with the plaintiff's lawyers, who, as I said, have collectively hundreds of years of knowing what happens in court. What happens with the person who abused you was your scoutmaster, but also with your stepfather or an uncle. And, the Boy Scouts are going to go, well, it wasn't that person in his capacity as a Boy Scout that abused you. He was a family member. That's how he got access to you. And so those are sadly the kinds of things that happen at trials. There's a lot of finger pointing going on. And then you have people, this is a very classic example. He was my priest. The people in Guam, a lot of them, if not most of them, were abused by a guy who was also a priest who encountered them in the church setting. This idea of, well, is it the church's responsibility? Is it the scouting experience? And so what John's scrolling through, he's now looking at what we call the base. That's where I got the 600 for the penetration. There are caps. This doesn't, a $600,000 claim cannot, with all of the enhancement factors, become 4 million. It caps out at 2.7. So your enhancing factors, when you multiply them out, might get you above 2.7, but that's where it stops.
Hey, Jim.
Yes.
So I want to sort of mention to everybody, I mean, we put this up on the screen. The TDP document is long, it's detailed, and we'll admit here, it's not easy to get through. But I think everybody has to try to recognize that, there are approximately 84,000 claims here. And while a lot of the things that happen to people are similar in nature, they happened all over the country, or in some places in different parts of the world. And because of that, and at different times, sometimes 5 years ago, sometimes 50 years ago, sometimes 25 years ago. And because of all the different states, all the different laws, and all the different times in which these events occurred, and the different levels of evidence that people might have, it requires a process, unfortunately, that is complex because we're trying to take into consideration all those differences. And it's very, very difficult to boil it down to something simple. So if you open up this document, you don't quite understand what it's saying, that is one reason to have counsel, but we're doing our best here to try to explain it to you in the simplest of terms.
Yeah, and I think the thing that probably complicates it even more, John, is that, there were multiple parties with different desires in the negotiation. You had the BSA, you had the local councils, you had the TCC, you had the coalition, and everybody was coming at this with a little bit different slant. So, get some help getting through this. Take your time reading it, but it's not the end. And I think one of the things we're going to get to is this is just an RSA and a term sheet. What comes next is some hearings and then plan confirmation. So Jim, I'd like maybe you to say, well, where do we go from here?
Sure. John, do you want to take us off the screen share and come back to Faces, just so I can, thank you. So where do we go from here? Currently, the Bankruptcy Court has a hearing scheduled for July 20th and 21st to review this restructuring support agreement and the Boy Scout request for its approval. The important part of the RSA in the context of the path forward is the Hartford deal. Because as I said before, the motion requests not only approval of the RSA, but also a determination that the Boy Scouts are not required to include in their plan the Hartford settlement. If the court determines the Hartford settlement as it is written has to be included, all of the parties to the RSA get to walk. So July 20th and 21st is a really important hearing. That hearing is also the scheduled time for approval of the disclosure statement, the document that will tell you the information to help you answer the question, should I vote for this plan? Which of course, if you have a lawyer, you should do in close consultation with your attorney. If the court approves I'm gonna do better. When the court approves the disclosure statement, because we're now a party to the RSA, the court will set a plan confirmation hearing. That is the hearing where the court will determine if the plan should be approved. Between the time the disclosure statement is approved and the court convening that hearing, creditors will be afforded an opportunity to vote yes or no on the plan, and will also be given an opportunity to give legal arguments about why the plan should be confirmed, if you want to join, and if you object, why it should not be confirmed. As part of the package of materials you get, there will be the plan, the disclosure statement, a ballot, which you will be expected to return, which you can work with your attorney on how to return it. Some of these communications will go to your lawyer and not to you personally. So you need to be in touch with your counsel about whether how you get access to these materials if you've hired a lawyer. It will include letters from the TCC, from the coalition, from the future claims representative as to the recommendation to vote yes on the plan. And so when you vote, and those votes are tabulated by the court, those votes are one of more than a dozen factors that the court considers in whether to approve the plan or not approve the plan. Who's expected to object? At the present time, we expect the insurance companies to object. Will individual survivors or groups of survivors object? Possibly, but we hope through the continued negotiations and documentation of the plan and the disclosure statement to try to meet as many of those concerns as we can and to make this even a better and better plan. But as it stands, the term sheet is what we have signed on to for the restructuring support agreement. So when will that confirmation hearing be? It's a little hard to tell, folks, because the litigation over should the plan be confirmed is a little up in the air. If you were talking to the Boy Scouts, they would tell you that they would like to have the plan approved by the end of, John, what are we, in October?
No. So here,
September?
yeah. It's I could sort of go through a very rough timeline, and everybody, this is highly conditional. This is best case scenario from BSA's perspective, and none of this is written in stone. And so we would have a disclosure statement hearing on June 20th, 21st. There would be a voting deadline around the first week of September, which has not yet been decided, but I'm just giving you a sort of a guide. And then a confirmation hearing the last week of September, maybe going in a little bit into October. And so that would be a best case scenario. But once the disclosure statement is approved, there will be a notice that is sent out, and that notice will have the definitive timeline. That is just sort of a ballpark sort of estimate of some of the big milestones that happen between now and then.
John, one more thing, and then I'll, I see you look at your watch. How much will I get? The answer is, we don't know. We have laid out for you the valuation of your claim. That's what the TDP is about. But how much will the trust actually have to pay out is very uncertain. It's really up to chartered organizations and insurance companies as to how much is going to come into this trust. When I say up to them, obviously we're going to make our demands and we'll litigate those if need be, but those are the sources that are left. And we don't know the answer to that yet.
If I could just jump in, I've been looking at the questions, and I think the number one question tonight must be, where can I find these documents? And I know everyone's anxious to get their eyes on them as quickly as possible, but they will be uploaded. You can be able to find them at the tccbsa.com website as soon as we can get them up there. And just as a reminder, we also record these sessions as well. So we'll have a link to this session so you can watch it again.
Yeah, we're hoping to have them up on the website by mid-morning tomorrow.
And I think we're trying to draft bankruptcy for dummy draft. So guys like me can read it and understand it. So that should be up in the next day or so as well on that same site.
By the way, John and Doug are practically going to get graduate degrees in bankruptcy, but there will be an FAQ. I can't tell you it'll be up by mid-morning tomorrow, but we had started working on a FAQ for the plan. The plan has changed a lot since we first picked up the pen on that, but we do intend to have something that will help you through this process in terms of what these documents say.
And look, this was a fire hose tonight, folks, and we're trying to keep it to an hour. If some of your questions did not get answered, we're looking for a way to put those in the FAQ and maybe get some of those questions turned around on the website. But stay tuned. As you know, this thing can be very fluid, and court dates can get changed and moved, as we've seen over the last 3 or 4 weeks. John, did you have something else?
Yeah, I wanted to say about questions. Remember, the website is www.tccbsa.com. And there you could also find our email address, which is bsasurvivors@pscjlaw.com. It's there. Don't have to, it's there. Go find it. And if you have questions, please send questions to the email address and we will get back to you. But one thing I also want to say and highlight for everybody here, remember that if you have counsel, you should work with your counsel to ensure that your counsel or your attorney understands what you want to do about the plan. Do you want to support it and accept it? Do you not want to support it and you want to reject it? Remember, the decision is yours, and that you need to discuss that with your attorney and communicate your decision to your attorney so that you can make your voice be heard in the way that you want it to be heard.
Yep. Thanks, John. All right, everybody, stay tuned. We'll keep communicating in this manner as long as we can. So thanks for your attention. Have a great evening and have a really happy 4th of July. Thanks a
Hang in
lot.
there,
Take
everyone.
care, folks.
Thank you.